Morning, everybody. Welcome to the Committee on Environment and Natural Resources. And we'll start off first with introductions. So we'll start with a good Representative Martin from someplace up north.
Thank you very much. I'm John Martin, House District 151. I represent everything from Allagash through to Fort Kent on Route 161 down Route 11 to Oxbow.
Good morning, I'm Ben Shipman. I serve as a state representative for House District 40 in Portland.
Hello, my name is Andy Buckland. I live in Farmington and I represent the folks in Farmington and New Sharon, designated as District 113.
Good morning. My name is Ralph Tucker. I'm from Brunswick, Maine, and I represent House District 50.
And I'm Bob Duchesne, House District 121, which is Milford, Dalton, Argyle, Hudson, and Corinth.
Welcome, everyone. I'm Joan Welsh. I represent Islesboro, Camden, and Rockport.
Hello, I'm Jeff Hanley. I represent District 87, which is Princeton, Randolph, Allnorth, and Wiscasset. Good
morning. I'm Denise Harlow, and I represent District 36, which is part of Portland and the part of Wilton that Senator Saviello doesn't live in.
I'm Dick Campbell. I represent District 130, which is West Port and Arlington.
Good morning. I'm Senator Kathy Green, and I represent Falmouth, Cumberland, Yarmouth, Gray, part of Westbrook, and Chehalis and Rhode Island.
And I'm Senator Tom Saviello. I represent District 17, which is all of Kennebec. All of Franklin County, parts of Kennebec, and a little tiny bit of Portland where Representative Harlow does live. Welcome to this Committee on Environmental Natural Resources. We'll be dealing with LD 750. We will be using the 3-minute clock once other people get up to speak after the sponsor and the DEP. However, we will have great flexibility because we don't have the overflow crowd that we anticipated. So you get to the end of your testimony, you'll see the light blinking, you'll see me offset it and give you the time to finish. And then we certainly will have the questions that will help you do that. So our intent is to try to keep things moving. Looking at this group, I don't need to remind you about civility. We've been dealing with a lot of that in the Senate, and what we appreciate that you're here. Very much thankful to that. We welcome your input. And we just ask you to keep to the testimony in front of us, and not individuals or other groups that might be involved. With that, I think we're ready to go. I think Representative Chapman is here. There he is, and we're ready to get started. Thank you, and good morning.
Senator Saviello, Representative Welch, and members of the Joint Standing Committee on Environment and Natural Resources. My name is Ralph Chapman. I represent House District 133.
Excuse us.
I found myself getting louder and louder. Good morning. Senator Saviello, Representative Welch, and members of the Environment and Natural Resources Committee. My name is Ralph Chapman. I represent House District 133, the 6 coastal Hancock County towns, including my hometown of Brooksville, which is the location of the failed Callahan mine, and the largest town in my district, Blue Hill, which is the location of the failed Kerr American mine. I bring before you today LD 750 as an attempt to solve 3 problems that are before the committee, and I'll be brief on 2 of them. But the first one, which I'll actually get to last, is the policy problem, how to effectively regulate metal mining. The second problem is a process problem. How do we honor the processes of participatory government? And the third is a political problem, which I'll say very little about because everyone on the committee, by virtue of being publicly elected, can be considered in some sense an expert on politics. But let me point out that people of the state are not happy with the prospect of financially paying for and simultaneously suffering the consequences of environmental pollution that benefits only a private entity. This is the goal for a regulatory structure to prevent that from happening. And people are not happy with governmental processes that seem tilted to favor the interests of a private entity while excluding public input. And that is with reference to the process problem that I'll get to now, which is actually more important than the mining issue that I bring before you, but I'll be brief. And it has to do with the fact that those who are governed need to participate in the formation of the policies that govern them. And you know that this issue has come before you in this session in a manner which has a problem relative to Maine's Administrative Procedures Act. And the point I want to make here is that passage of LD 750 gets you completely around that problem. There is a technical way for you to get around the problem of inserting a single sentence in legislation passed by the legislature to make legal what was heretofore illegal in bringing some other rules before you. The problem with solving that problem that way is that makes the legislature have to acknowledge that we want to exclude, that it's okay for us to have excluded the public from the process of having input into the rulemaking as is their statutory right through the Administrative Procedures Act. So, although we might do it, I would say it would be an unacceptable solution to have the legislature work in that way to undermine the public's involvement, in part because it also discourages the public from participation in their government, which I think is very important. So let's get right on then to the policy matters involved with regulating metal mining. And it's important to recognize two background pieces of information. One is metals are important to our culture. In fact, our ancient history is defined in part by what metals we have used when we went from the Stone Age, when our ancestors went from the Stone Age to the Bronze Age using copper and tin, and then on to the Iron Age. We demarcate those events of the last few thousand years by recognition of what metals they were able to use. Our technology has advanced significantly since then. We use metals for a very wide variety of very important societal functions. Metal mining removes metal-rich ores from underground, concentrates, separates the metal from other rock, transports, refines, and eventually sells the metal. That is the activity of mining. A problem is that the extent of mining operations is limited by the ratio of the cost of the operation to the commodity price. A profitable operation at the location of high concentration ore becomes less profitable as the operation moves to lower concentrations, because the extraction costs stay relatively constant, whereas the amount of product sold diminishes. So while mining is economically self-limiting, always moving toward the edge of non-profitability, every cost associated with environmental protection, every single cost associated with environmental protection takes away directly from the profitability of the operation. And for that reason, it's a particularly difficult matter to regulate in a fashion that allows the operation to continue and yet controls it in a way to protect the public's interest in both not paying for it and not suffering the consequences of environmental degradation. The standard solution that has been applied to this general problem of how to regulate metal mining is to increase the financial costs for the operation that pollute through a legal structure that permits operation and levies fines for noncompliance. In other words, it's a punishment. If you do it okay, that's fine. And if you don't, we charge you fines and we penalize you in various ways that we can, such as removing your permit to do any further damage, etc., etc. The problem why the standard solution fails us in the case of metal mining is because the non-compliance costs are too great for the mining entity, which cannot afford the remediation costs. The average stabilization cost for mine failures today in sulfide mines is in the range of $300 to $500 million per mine failure. That's simply too expensive for most mining entities. That's the average. That's not a worst case. That's the average. And the expenditure of that $300 to $500 million adds nothing to the mining company's income. Their income derives from the extraction of the metallic ore and the selling of the metals. The imposition of fines contributes to mining company bankruptcy, hastening the time in which the public becomes financially liable. The Kerr American mine liabilities are now in Blue Hill are now owned by an entity with very little assets. Further costs to contain metal dissolution in the Maine waters at the Kerr American site will be at public expense. The Callahan mine expenses are already have been and continue to be borne by the public, and as you know, the expenses that the Maine taxpayer pays are located in the transportation budget. It's a total of about $2.3 million in the last few years. To cover the estimated $23 million costs that was about a 5-year-old estimate, and before some additional contamination on the site was discovered. So as taxpayers, we're paying for remediation costs at the Callahan mine. It's listed on the National Priorities List as a so-called Superfund site managed by the Environmental Protection Association. Administration. So few, if any, I don't know of any, sulfide mines have met the terms of their permits. The industry study in the late 1990s could find no examples of sulfide mine compliance in connection with Wisconsin's Prove It First mining law. The industry studied its own history. The Wisconsin's Prove It First mining laws looked for a mine that had been closed for a period of 10 years and had not suffered a non-compliance issue with the permits. And the industry could not find one. Those are the reasons why the punishment paradigm for solving the problem of regulating metal mining does not work. The reasons why these volcanogenic massive sulfide deposits have been difficult to achieve the compliance with their permits is because the sulfide deposits are chemically reactive to aqueous oxidation processes, and I just call that weathering. These are materials that have been buried for hundreds of millions of years, and when exposed to oxygen and water, the reactions create an acidic solution that then dissolves the metals and carries them downstream. And that is actually the difficulty, the recent difficulty at the Kerr American mine. 5 to 6 tons of zinc was being washed into the Carlton Stream towards Salt Pond in the ocean in Blue Hill until a $10 million geosynthetic cover was placed over waste piles about a half a dozen years ago. So the consequences of following this standard, what I call failed regulatory framework based on punishment, is taxpayer cost, environmental damage, loss of traditional industries. We threaten the tourism industry, fishing, agriculture, if we have environmental disaster at a mining site. And economic decline is typically the result. And I would encourage anyone who's interested in the question of jobs and economic decline and so forth to take a look at other examples, such as the city of Bathurst in New Brunswick, which has suffered a 40-year decline in population, has a greater than 20% unemployment rate. But let me carry on with the gist of what I'd like to present to you, which is a paradigm shift away from punishment towards prevention. We need a regulatory structure that can prevent the problem, because we as the taxpayers don't want to, and an industry entity cannot pay for the damage that it could cause. therefore we have to prevent the problem. Let me just comment before I move on to that, that a failed mine, a mine in which the acid reactive drainage has begun, requires then filtration, chemical modification of the wastewater, of the precipitation that's draining out of a mining area in perpetuity. And I just want to make the point that if that is the mechanism of control of a failed mine, those costs, the public cannot avoid being the entity that pays for those costs, because the value of any mine deposit is less than the cost of perpetual care in treatment of acid reactive drainage from the mine site. So let's look at the goals for a prevention-based regulation. It's not easy to shift from the punishment paradigm to the prevention paradigm, and I'd like to take a moment to explain that 2 years ago I presented a bill before another committee here in the legislature to deal with the problem of mining, in which I thought that I had a fairly simple and easy to implement mechanism for increasing the costs of non-compliance. And I now know, 2 years later, that that approach that I took sincerely 2 years ago is not a correct approach. The reason I'm telling you about this, it didn't raise a lot of attention at the time, and in some ways I should just let it go and not bring it forward, but I want to let you know that this is an example in which, as intimately involved as I've been with the mining issue for many years, and having the only metal mines in Maine in the last 100 years in my district, it is only in the last 2 years that I've been able to recognize the need for this paradigm shift from the punishment to the prevention side. So I sympathize with your positions that in which you may be looking at this in some ways for the first time from a different angle, and I appreciate the difficulty of understanding its implications. The goals for a prevention-based regulatory system, and this is the most important aspect in my opinion, is that a geologically stable mine site is what is the goal at the end of the mining process. And additionally, we want to maintain the non-contamination of the environment, and we also want to maintain the public being free of financial responsibility. So additional aspects that are necessary include we need to work with responsible parties, and we want to incorporate as much expertise as possible, since it's a highly technical topic. This is a matter of personal interest. Trying to bring technical expertise into the public policy making process has been a long-term goal of mine over many decades, and I am attempting to do so in this instance as well. It is not easy to legislate the access to expertise. That requires cooperation. But nevertheless, if we can state the goals and show a pathway towards it, although we can't guarantee success here, I think it puts us in a much better position. So, the matter of needing the cooperation of the executive branch agency, as I say, is something that we cannot legislate. I want to make reference to something that was heard at a public hearing about a month ago, in which a spokesperson for the DEP, and we don't need to say who because it's not a personal matter, made the comment that the LD 126 rules provided money to clean up the worst case scenario. And I present that quote as an illustration of what I will call an institutional ignorance about the problem. I've indicated to you before that the average costs of mine failures now is in the range of $300 to $500 million, and so we have actually two problems in the statement that was made. One is a worst-case scenario certainly could not be accommodated by the punishment regime that we have been trying to implement. And secondly, the concept of cleaning up is problematic in itself. You remediate mine sites, you stabilize them, you try to cleanup is pertinent to different types of problems than the weathering of sulfide materials resulting in acid reactive drainage. So the three major elements of LD 750 is the goal for geologic stability, the rejection of irresponsible applicants and high-risk processes, and the incorporation of third-party expertise and process decision points. One additional matter, which is minor but important, is a moratorium. And the moratorium is there to solve the problem, the process problem. We're in a legal limbo at the moment with respect to what happens if an application for mining were put in place prior to the final implementation of rules that regulate it. Now, geologically stable, the primary point of LD 750 means impervious to physical, chemical, or biological weathering processes that form a toxic metal transport mechanism that can create off-site contamination within a period of 1,000 years. So I'd like to discuss this for just a moment. I've indicated what weathering processes are, how those weathering processes move toxic materials downstream, wherever the water goes, which is everywhere. Let me comment on the period of 1,000 years. I have to admit, I pulled that number straight out of the air. And I looked at it this way. From an order of magnitude perspective, should it be only 100 years or should it be 10,000 years? Human history written history does not extend as far as 10,000 years. I've indicated that we went from the Bronze Age to the Iron Age, or from the Stone Age to the Bronze Age, and the Bronze Age to the Iron Age in less than 10,000 years. So 10,000 years seems just an unreasonable, it would make no sense to put that into law. 100 years, well, we discuss things like 100 years when we talk about the probabilities of floods, storms, those sorts of things. We talk about it as a means for discussing the probabilities of a 1% per year chance of something happening. We call a 100-year event. And similarly, as you know, we've been discussing 500-year time periods for certain extreme weather events in connection with metal mining rules. So from an order of magnitude perspective, the 1,000 makes sense. It should not be as short as 100. It makes no sense to be as long as 10,000. But I did want to explain that I don't think it's worthy to argue over whether it should be 900 or 1,100. This is an order of magnitude number. Now, relative to the other aspects of the bill, the rejection of irresponsible applicants or high-risk processes, I would ask the simple question, is there justification for allowing an irresponsible entity to mine in Maine? And the bill lists what some of the characteristics are of responsibility or irresponsibility on the part of a potential applicant. And similarly, is there justification for allowing high-risk mining processes? And the bill lists several high-risk mining processes that it says are unacceptable. Third-party expertise is essential since the needed expertise does not and cannot exist within the governmental agency of jurisdiction. and this is not a criticism of the good people that work in the agency, this is simply a statement that in which we understand that the industry that does not exist here is not able to support expertise within a department that has had so little to do with the industry for such a long period of time. And for that reason, one has to import the needed expertise. The temporary moratorium solves the legal limbo status created by, presumably by mistake, in the 125th legislature's decision to remove by date certain statutory environmental regulations during the unconstrained time period of the rulemaking development. So I don't believe it was intended for the statutory provisions to be removed prior to the implementation of new rules. I think that the delay in the implementation of new rules caught us off guard by removing the statutory provisions that those rules made reference to. And finally, I would caution the committee not to undertake rulemaking by committee. Although the motivation to do so is clear, there are two reasons arguing against it. One is the committee here lacks the resources to access the needed expertise. By resources, I include monetary resources to pay for expertise. And secondly, the committee processes, although legislatively there is a public hearing process as the one we're involved in today, the processes do not include the same level of public involvement in rulemaking as does the substantive rulemaking processes of the department. And so for those two reasons, I would caution the committee not to engage in rulemaking, but to ask the department to do that. I'm happy to answer your questions now or at any time. Thank you.
Questions? Representative Martin.
Thank you very much. Before asking any question, I do want to point out, President Chapman, that the money that goes to solve the problem in your community, your mind, actually, if I would call it that, is actually general fund money. And the general fund appropriates the money to the Department of Transportation, who's responsible to carry it out. And that was done at the time that we ended up being responsible, declared responsible by the federal government. Because of the fact that they did not want an agency to be supervising DEP, that is, the work. And so the work is actually done by transportation. But the general fund, as a matter of fact, the budget contains a provision where the money is appropriated and then transferred over to transportation. I don't want anyone in DOT to assume that their gas tax is paying to solve the problem in your mind.
Right. Thank you for the clarification.
So I don't want to, I just want to make sure that that's the beginning point. That I can see someone give me a call tonight saying, how come DOT, my DOT money is paying to that mine? So it's general fund money.
I meant to say that it appears in the transportation budget.
It does, but the appearance of where it comes from also is from the general fund.
Which comes from the taxpayers.
That is correct. I'd like to begin perhaps a couple questions, and I don't want to discuss today, but the APA issue, which I disagree with your position, but that's a matter that I think the legislature has resolved because it accepted the bill and we have it before us. But if someone wants to question that at some point, they can always go to court and deal with that issue. So I'm not going to talk about that today, but I don't think it matters. The question I have though deals with, is there an assumption that whether we proceed on the way you're approaching it or the way the committee right now is approaching it, that we will make the final decision as to whether or not a mine would operate in Maine?
I'm not sure what the question is. If you're wondering whether
what I'm basically asking is not the final authority, assuming we follow through, or we follow the way you want to go at this point, and that happens, then there will be and assuming that the rules are put in place, an applicant's going to file. And that matter at that point will be where the action will be for both proponents and opponents to see whether or not a license should be granted. So we're a far cry away from being in a position where we, or under this process or the process that we're going over now, would ever be in a situation where we would ever decide as to whether or not mining were to occur in Maine.
I recognize that the decision-making process is a process, and that occurs over time. An important portion of that process occurs before this committee during this legislative session. What you do will influence what the legislature does, and what the legislature does will influence what, if anything, the department does, and that will influence what the rules are under which an applicant may choose to make an application, and it will set the standards by which a determination can be evaluated relative to those that think it should proceed and those that think it should not proceed. It defines the way in which it would proceed if it does. Have I addressed your question?
Well, I think you're getting to the point of agreeing that we are not in a position to make the decision. We are in the process of making, whether your process or the process we're following now, we set up a standard. The department will then take the applications, if there are any, and then you or I or anyone can then file against the action or proposal that the applicant makes, as well as anything which the department chooses to do.
Surely, but if I'm making the point that the evaluation of those proponents or opponents to a pending application are going to be reflected by what the rules are, and that's reflected by what the framework is, and that is not only before you, but in my opinion, the responsibility of your committee.
Are you assuming that the process you would use, the way you've laid it out, would end up with a different result than where we are today with what's been filed?
Absolutely.
Why?
Well, let me rephrase it slightly. When I said absolutely, my process will not guarantee a positive outcome. But I think the process that you have been following up to this point is fairly certain to have a negative outcome. And I tried to outline that in my presentation, involving a punishment protocol as the motivating factor for having the mining operation be done in a way that doesn't cost the taxpayer money and doesn't contaminate the waters of the state. That whole process has been shown so far not to work anywhere. In other words, we cannot find a mine in which the terms of the permit have not been violated based on that punishment paradigm. I've been trying to present a paradigm in which the prevention is key, which means the goal is stated. I didn't mention the necessity of the waypoint decisions. That is to say, as information is gathered in the process of operating the mine, one might very well find circumstances that were not known beforehand that require a decision to stop the process at that point. This would be typically known as a go, no-go decision point process, waypoints. Important concepts are the inclusion of third-party expertise, the go, no-go waypoints, and all toward the final goal of geologic stability. That coupled with responsible entities and disallowance of high-risk processes, all of those differ from what you have before you prior to today. That is to say, you have not provided a mechanism so far to prevent irresponsible entities. You have not so far provided a mechanism to disallow the high-risk processes. You have not identified as the major problem to be addressed the long-term stability of the mine site. That might do it.
Just remember that the process that the committee right now is ongoing hasn't gotten to the stage of making any recommendation on those issues. And knowing the crowd that sits around this committee, I find it difficult for that to say that they're not going to, knowing some of the makeup of the committee. But that's really a different issue. I mean, I think when you look at what you're doing with the moratorium issue, you're basically saying you're going to have the same process that what took place before. Now, it may be that there may be a few things different that the BEP board may do a little different, may say a little different, but it would still come before the committee, and I rest assured that whether it's now or then, there still would be changes that would be proposed by the committee, would be my gut feeling. So I don't see where that would get us anywhere. But let me ask my basic question, I think. Wouldn't it be more accurate to say what you really want to do is put in a bill to outlaw mining in Maine, period?
No, that's not correct. I can understand the point of view that people may have that think that metal mining